number 74, the people of the state of New York versus Mouhamed Thiam. Good afternoon, counsel.
Good afternoon, Your Honors. May it please the Court. My name is Catherine Kulkarni, and I am here on behalf of the appellant, the people of the state of New York. At this time, I would respectfully request 2 minutes for rebuttal.
Of course.
Thank you. Because the defendant was charged in a misdemeanor complaint with at least one facially sufficient misdemeanor count, the criminal court had jurisdiction over his prosecution and was, therefore, authorized to accept his guilty plea to 7th-degree possession of a controlled substance, even if that charge was not sufficiently pled.
There are a lot of terms being thrown around here. There's personal jurisdiction, there's trial jurisdiction, there's subject matter jurisdiction, and then on top of all that, there are mode of proceedings errors. How do you differentiate between those, and what do you think we're looking at here?
Sure. So we're looking at jurisdiction over the defendant's prosecution, and for our purposes, subject matter jurisdiction.
Is that really correct? Aren't you really looking at jurisdiction over the person as opposed to jurisdiction over the crime here? Isn't there a distinction drawn between an accusatory instrument and a prosecutorial or prosecutable instrument? And here we're talking about the fundamental misdemeanor complaint, which is an accusatory instrument which gives a court control over the person.
That's correct, Your Honor. And so for our purposes, personal jurisdiction and subject matter jurisdiction are one and the same, and they are both established with the filing of a valid misdemeanor complaint.
That's not what the CPL sets out. The CPL does not set out a situation where personal jurisdiction and subject matter jurisdiction are the same. Let me give you an example. I was a city court judge when I first became a judge, and all the time they would bring in people for felony hearings, or people who've been arrested for felonies, and I would arraign them. I had jurisdiction over their person to arraign them. I had no jurisdiction to hear the case at all, or to decide the case at all. I had no jurisdiction over the crime, over the subject matter. I only had jurisdiction over the person to set bail on them, to set it down for a felony hearing or refer it to the grand jury. So the CPL seems to clearly contemplate a difference, and each court's jurisdiction, based on the size of the court and jurisdiction of the court, will change. But so that fundamental distinction here, the way I understand it, is we're talking about the basis for that distinction. And the way I understand the defendant's argument is you may have jurisdiction over the person, maybe, but they don't say you don't even have that, but you clearly don't have jurisdiction over the crime here.
Nowhere in the CPL is the term subject matter jurisdiction mentioned. It just generally mentions.
That's true.
So respectfully, the CPL doesn't stand for this distinction that my adversary is trying to make. And in fact, in Kaiser.
Let me just get this clear.
Sure.
You would say that for jurisdictional purposes, you have both jurisdiction over the person and over what that person is charged with once you establish that you have jurisdiction.
That's correct, because subject matter jurisdiction, there's absolutely no support for finding that it is specific to each offense charged in the complaint. In fact, this court's decision in Kaiser couldn't exist if that were the rule, because this court held that the filing of a valid misdemeanor complaint gave the court jurisdiction over the defendant's prosecution.
What about some other cases like Hightower, Dryden?
Sure. Well, Hightower, unfortunately, we didn't make the argument that we're making now. In Hightower, we made a different argument. But again, because we didn't make the argument in Hightower that we're making now, extending Kaiser to this case does not require the court to overrule Hightower.
What was the argument in Hightower?
I'm sorry. Yeah, how would you get around Hightower?
What was the argument that was made in Hightower? What was that about if it wasn't about this?
So the argument we made in Hightower was, regardless of whether there's one sufficiently pled count in a misdemeanor complaint, the defendant forfeits his right to make a facial sufficiency challenge by pleading guilty. Here we're saying where there is one sufficiently pled count in a misdemeanor complaint, that gives the court jurisdiction to accept the defendant's guilty plea to any count in the complaint, regardless of whether it's sufficiently pled. And because this isn't a jurisdictional issue and the court has jurisdiction, by pleading guilty, the defendant forfeits his right to challenge a facial sufficiency of the crime to which he pled guilty, like he does most
But
claims.
didn't Hightower ultimately rest on the question of whether the complaint should be dismissed or remitted as to whether there was a penological purpose under Allen to do it over or not?
Well,
isn't that what that whole dismissal thing was about in Hightower?
in Hightower, the court just considered the sufficiency of the offense to which the defendant pled guilty, said it's insufficient. Because this is the offense to which the defendant pled guilty, we don't need to look to these other offenses in the account, therefore dismissed. In the complaint, therefore dismissed. So the court did not actually consider the argument that we're making now.
Hightower, to me, also seemed to be a different challenge to the count itself. And granted, some of our cases are a little bit here, a little bit there, but in Hightower, I thought the problem with the count that was pled to was that even assuming the allegations as in the complaint, you couldn't show that the money that was taken from the swipes belonged to the transit authority. So even assuming all of that, it was legally insufficient in a way to prove the crime charged, even if you accepted what was being said. In this case, it seems it's more of a traditional hearsay challenge, but one of our hearsay categorized as by the police officer hearsay, right? So the question is, when you plead to that with a legally sufficient charge, and assume for the moment, I know they're challenging it, that the marijuana charge is legally sufficient, but assume it is, would we apply that same rule on waiver when you plead to a misdemeanor if assuming what was alleged would make out a crime? That seems to me the difference with Hightower.
Yeah, I think that's an important distinction, and as Your Honor highlighted here, that there's no reason to believe that we couldn't have amended the complaint to include more detailed allegations. The officer wrote that based upon his training and experience, he knew the pills were oxycodone. So we have every reason to believe he could have explained how he knew, even though it wasn't in the complaint.
And I guess the argument would be in Hightower you couldn't do that because the money just didn't belong to the transit authority.
Right, we don't have that situation here. And by the way, the defendant pled guilty to this crime, so he admitted that he was guilty of possessing oxycodone. So this isn't a case where we're worried about the people overcharging the defendant with the crime because point blank he pled guilty and admitted his guilt to it.
Dryden seems just like this case, but for one thing, and maybe there's others I haven't anticipated, but the difference to me seems to be that the validly pleaded allegation there related to a violation rather than to a misdemeanor. Does that make a purpose for jurisdiction, and if so, why?
It does, Your Honor, because under this, the CPL expressly authorizes a defendant to plead guilty to any count in the complaint in satisfaction of the entire complaint. It doesn't mention anything about the class of the misdemeanor. So under the jurisdictional rule we're advocating for, and under the plain words of the CPL, it has to be a misdemeanor count to give the court jurisdiction to accept a guilty plea to an insufficiently pled misdemeanor count.
Let's say we think and we agree that, in fact, there was a violation of a CPL Article 220 here. Why does that violation not rise to the level of a non-waivable violation?
Sure. Well, first of all, I would like to disagree with this being a violation of the CPL. It's actually expressly authorized by the CPL. And finding that this is not a jurisdictional defect is in line with the legislative intent behind the pleading requirements set forth in CPL, the way to cure a pleading defect, and also the legislative principle that plea bargains are intended to be final. The legislature has made clear that where defendant, may I continue? I see my time is going.
Please.
The legislature has made clear that where a defendant has pled guilty, he forfeits most claims, and only the narrowest class of claims are an exception to that. Under the CPL, because we have these specific provisions in place that require a defendant to move to dismiss the accusatory instrument before sentencing, and that provide that an accusatory instrument should be amended, should not be dismissed if it can be amended. The legislature made clear that it intended pleading deficiencies to be litigated before a defendant pleads guilty. And by not litigating these pleading deficiencies early on, as the defendant chose not to do in this case, and instead accept a favorable plea deal that was a very good disposition for him, the legislature could not possibly have intended for years later the defendant, having received that favorable disposition, to then move to erase the entire thing just because on the grounds that the court never had the authority to accept his plea in the first place. Thank you very much.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. Will Page on behalf of Mr. Thiam. I think since Kaiser is getting so much attention here, it's important that we focus on the context that Kaiser was decided in. In Kaiser, there were 2 facially sufficient A misdemeanors that no one challenged. And if we look at the DA's brief from Kaiser at page 9.
But in essence, although the defendant did raise a challenge here, he withdrew that challenge, didn't he? By pleading to the count that he pled to?
Well, I think sorry, Your Honor.
He said, instead of getting a decision on my motion or whatever it was, I'd rather plea. It's to my benefit to do that.
I think the same thing can be said of basically every facially insufficient case that's been before this court where the defendant has pled guilty. In the seminal case of People v. Case, Mr. Case pled guilty, and this court still considered whether or not the misdemeanor charges were sufficient. And if you look at how the DA expressed this law in Kaiser, the DA, Manhattan DA, said, a juxtaposition of Johnson, Ford, and Foster makes clear that a defendant may plead guilty to a crime that's not strictly within Article 220 of the CPL, so long as the crime is not of an equal or higher grade than the crimes actually charged. So at some point in time, we were all in agreement that these rules were here for a fundamental reason. Something has changed. Now, Kaiser is being interpreted as an expansion that can undo the long-standing jurisdictional rules this court put in place, one of the most fundamental protections that someone accused of a misdemeanor has. As the court knows, those accused of misdemeanors don't have a grand jury. So when...
But let's go to that. I mean, what is the fundamental purpose here? And I know we have Hightower, we have Dryden, but what is the fundamental purpose here? Because as I understand it, a person can come in, plead to a felony and an indictment, waives any defect in the grand jury, right? Waives. So if the analogy is the affidavit to the grand jury proceeding, and this is protection for the defendant, why wouldn't we allow somebody to waive that? If you're allowed to waive, you have a constitutional right to be indicted by a grand jury. We've spoken to it time and again. You can't waive indictment in many cases. Why would we let you plead guilty, and you waive defects in a grand jury proceeding, which maybe you didn't put in proof of the murder, but you can't waive as to whether or not you have a personal reason to believe this is oxycodone? What's the purpose of that?
Well, the one fundamental protection that a misdemeanor accused has is that the conviction they've pled to is going to have some factual basis to support that charge or a higher level offense, and there's none here.
That, to me, seems like either a due process or a double jeopardy issue is the only fundamental reason I could see there for doing that. So if you plead to this charge in this complaint, what is the fundamental defect there? You're not going to be re-prosecuted for possessing oxycodone on this street corner at this time, so there's no double jeopardy issue. Is there an issue with you couldn't have prepared your defense?
Well, I mean, technically, I'm not sure what you could be prosecuted for, Your Honor, given that there's no description of the pills here. There's no description of whether they were in any kind of baggies.
What happens in these cases, drug cases, he's got 8 pills on him. Policeman says it looks like Oxycontin because it's looked like Oxycontin before. But you don't have a prosecutable instrument until you go back and get a drug test, and it comes back and confirms that they're that. And it does happen that people, when they're selling drugs, sell what's known as bunk, which is, usually that's the core of, in my personal experience, that's been the core of these arguments. So they're selling something that it isn't drugs, and they're charging people for it. They're selling aspirin tablets. So they say, You can never prosecute me for a drug violation. I was selling aspirin tablets.
Exactly, Your Honor.
And I sell them to people that are buying my marijuana that I was also charged with. So, from a cynic's point of view of the world, that's the strategic reason why you would do that. And that's also probably why you would plead to that charge. But without a drug test, you do not have a prosecutable instrument ever.
And referring to one of your questions that you asked earlier, the CPL does actually recognize this distinction as well between personal jurisdiction and subject matter jurisdiction, in that the CPL 120, 24, and 25 discuss preliminary jurisdiction, something that the DA doesn't mention.
I want to ask you some practical questions. You're in arraignments, and you have this A misdemeanor, and you have a B misdemeanor, let's say, that's made out. Let's say the B misdemeanor that's made out is some sort of a groping or, some sort of sexual offense on the subway. And that's clearly sufficient. It's adequately pled out. And when they arrest him, they recover 6 oxycodone pills, all right? But it doesn't make out all the allegations that you need under 100.40, and it's insufficient. And the guy says at arraignment, Judge, I want to take that plea because I don't want to have to register as a sex offender or whatever, or go through a SOAR evaluation. So what's the judge supposed to do? Put it over to have them cure and bring him back? The judge was willing to give him time serve. And I'm a little concerned about the reality of what's going to go on in criminal court.
Well, we're really talking about throwing out all of the longstanding protections in favor of probably a really small subclass then.
But if that defendant is making a knowing choice by pleading guilty, getting back to, I think, some of the points that Judge Garcia was making, what are we achieving in that hypothetical?
And is that a small subset in this day and age of immigration consequences and SORA and other collateral consequences that have become quite significant?
Absolutely. And I think it's an interesting question in the co-equal context, Your Honors, where perhaps one has those consequences and one doesn't. But that's not our case here. I mean, we have a case that doesn't have those considerations where, because of a top count that was facially insufficient, Mr. Thiam was in a position to plead up where there was no subject matter jurisdiction established. Now, immigration consequences aside, I think it would be hard.
If you can plead down, if you can plead to a non-existent fictitious crime, right?
Yes.
How could that be subject matter jurisdiction? That isn't even in the accusatory instrument. How can that be subject matter jurisdiction?
I think that's exactly what Kaiser was sort of trying to deal with, right? When Kaiser was delineating between the felony context and the misdemeanor context and recognizing that some of the constitutional protections don't apply to felonies and sort of slightly loosening it in misdemeanors, what we were recognizing was that you can't plead down to something that's not even related to charges in an indictment context, but with a misdemeanor you can. You can plead down to a lesser offense.
Doesn't some of that have to do with the constitutional requirements of prosecution by indictment and going before a grand jury in felonies that don't apply in misdemeanor cases? And if that's true, then aren't there statutory violations that aren't, call it whatever you want to call it, jurisdictional or mode of proceedings errors or whatever, that can be waived?
And that's what Kaiser was.
You agree that those
Absolutely.
exist. So, well, why isn't this one of them?
Well, Kaiser was recognizing that in the context of the quintessential lesser, the non-criminal violation to disorderly conduct. It cannot be the case that you've been hauled in on a low-level marijuana charge, and now, if you take Kaiser to its natural extension based on the district attorney's reading, you could also be charged with an uncharged A misdemeanor that could subject you to SORA consequences or immigration consequences, and I guess you could be offered a plea to that. That's a fundamental unfairness that's going to happen to the defendant, and apparently that would be a fair reading of Kaiser now.
So what about a situation where you have ungraded misdemeanors?
An ungraded
And there are,
misdemeanor.
things like the environmental conservation. There's a lot of ungraded misdemeanors out there. I'm
assuming those would also.
I'm trying to remember back to my days in the SAP part. you pull a fish out of the river that's the wrong size and you didn't throw it back. What about ungraded misdemeanors?
I suppose to the degree that they're not considered Bs or lower misdemeanors.
Oh, it's a prosecutable through a simplified information.
That's also correct, Your Honor. But, and also we could
There's
look at.
4 types of informations that are prosecutable. A grand jury indictment, an information, a simplified information, and a prosecutor's information. That's what we're talking about. That's what the judge is talking about. So to have a prosecutable instrument, though, is different than having an accusatory instrument. The accusatory instrument there would be the ticket that would be handed out to someone. This is a more difficult problem than you would have
Absolutely.
expected in this case.
And that's why I'm.
Counsel, if we agree with you, what does the criminal justice system, with respect at least to these misdemeanors, look like the next day?
Well, I don't think there's any real change. You're announcing a bright line rule that's easy for the court, the defendant, and the district attorney's office to follow, which is.
Why make a motion to dismiss?
Sorry.
Why make a motion to dismiss?
Well,
I'd take the plea, and according to the Miki, that way you walk out, you don't have to suffer the delay and the uncertainty, potentially losing your job, being apart from your family, et cetera, and so forth.
there will be defendants who will have the ability to make motions to dismiss, and we should be encouraging a system with those robust protections. But there are enormous pressures placed on
Was there a
defendants.
change in the law also that might impact the way this looks the next day?
I don't think, if Your Honor is referring to the legislature reducing some of the pressures, I don't think the pressures that many of our clients face deal with returning to court for many appearances. Those pressures are not going to be alleviated. I mean, being low income, having to tell your supervisor you're looking for time off, you have to return to court every 2 weeks, every month. You run the risk of losing your job, losing your housing. How do you arrange childcare for each of your court appearances? Those pressures are still in place, and those are enormous pressures that.
So won't those, but how else could you resolve the case then? If you're charged, let's say that it's really unclear whether there is a sufficiently pled crime, misdemeanor,
So not this
whatever.
case.
Well, whether it's this case or not, it's very close. It's very unclear. So then, doesn't any defendant have to make that choice? Am I going to plead and be done with this case, or am I going to make motions and so on and so forth?
And it will
So-
be within the purview of some defendants to do that. But this court's recognized that they're non-waivable jurisdictional prerequisites because of the fast-moving environment of the misdemeanor court, because of the fact that there's no, like you look at Article 220 and subsection 10 there, it's talking about pleading to any count of an indictment in order to satisfy the instrument. So again, we're assuming that a grand jury has already passed on the sufficiency of those allegations. That's not happening here. It's moving very quickly. An instrument's filed. We want to incentivize the system to ensure that there are facts collected by the officer, that those facts make it into the complaint, and that the prosecution uses their duty to ensure that charges that are supported, especially the top count, which is driving the misdemeanor prosecution, is present, that it's a facially sufficient charge.
So if I'm sorry.
Go ahead.
No, go ahead.
I was just going to say thank you.
Oh.
Sorry. Thank you, counsel.
Thank you.
Counsel?
Thank you. As Your Honor mentioned,
So
there.
doesn't his rule, or the rule he's advocating for, incentivize the proper pleading of these instruments? And isn't that what the legislature is also intending?
We're not seeking to do away with the pleading requirements. The people should still seek to comply with those in each and every complaint.
You know, where's the downside to making a mistake or not doing it?
Well,
Or being, shall we just say, not as careful as one might wish for the ADA to be?
Well, that's why we have these CPL provisions in place that allow for a defendant to move to dismiss, and a defendant can do
Again,
that.
that burden all falls there. Where do you incentivize the ADA to do it right in the first place?
Well,
What appears to me in the legislation to be a safety net that should be used in the rarest of cases then becomes the actual practice.
Well, our entire criminal justice system is premised on the notion that if a defendant has a claim to raise, the burden is on him to raise it. For example,
Yeah, but it's also premised on the presumption that the prosecutor is held to a higher standard, is indeed properly doing their job.
Right, well, again, the pleading requirements still exist. We're not saying that they shouldn't resist.
What would you
And
do
a prosecutor
here?
is still bound by ethical rules to not include completely frivolous charges in a.
What would your office do here tomorrow if we did rule the other way and this fact scenario came up again? Defendant makes these objections, lawyer makes objections, points out the problems in the misdemeanor complaint, and then says, would you offer a deal of time served 1 hour or 2 hours? Or would you say, we weren't going to take that plea at this point, right? Why would you ever take that plea in the future if that's the rule?
I'm sorry, if the court
If
rules
this
in the.
fact scenario came up again and we
Right.
rule for the defendant here, why would your office ever take this plea?
Well, our office will still take a plea if it's.
Under these circumstances? So it could get reversed on appeal?
Well, that's a good point, Your Honor. I mean, I think if the court ruled in my adversary's favor, the prosecutor would actually be incentivized to ask for a plea to every charge in the complaint.
Isn't what one hopes you tell all the ADAs is to ensure that there's not a deficiency in the instrument? So, no, get the drug test or get the proper information so that you satisfy the requirements. But I have a different question. Could you respond to Mr. Page's comment that the CPL does indeed recognize this distinction between personal subject matter jurisdiction to be found, at least as he had the opportunity to assert, at 120.24 and 25?
Sure. Again, even in those provisions, there's no mention of a distinction between subject matter jurisdiction and personal
What do you
jurisdiction.
read those provisions to apply to? What do they mean? What do they stand for?
They apply to the jurisdiction of the trial court or the criminal court over the defendant's prosecution, and that is established with the filing of a complaint with at least one valid misdemeanor charge. And I would just like to briefly mention this subject matter jurisdiction point that my adversary is making. He's obtaining this from a line in Harper, this court's decision in Harper, but Harper involved the mid-trial amendment of an accusatory instrument to add 2 counts. It was in the trial context, a very different context, and really has no application here. Thank you very much.